What up? 大家好，我是锁头 and welcome to part 2 of the judge's jury instructions. And if you enjoy this video, make sure you help us out by smashing that like button and share it to your friends. So you might not know this, but certain words that we use outside of the courtroom actually have a different meaning when used inside of the courtroom. And the judge is about to explain this very clearly when it comes to the words defamatory and malice.
A statement that is not directly defamatory may nonetheless suggest a defamatory meaning in an indirect way, that is, by implication. In determining whether any of the statements have a defamatory implication, you must consider the op-ed as a whole and the circumstances surrounding its publication. You should consider if these circumstances show that the words used are defamatory and relate to Mr. Depp. However, such circumstances cannot extend the meaning of the words used in the op-ed beyond their ordinary and common meaning. The proposed implication must be reasonably drawn from the words actually used. In determining whether any of the statements in the op-ed are false and defamatory as to Mr. Depp, you must read the statements in the context of the op-ed as a whole. This means you may not seize on any one word, phrase, or image, or consider only one particular statement, phrase, or passage in isolation. In determining whether any of Mr. Waldman's statements are false and defamatory, you must read those statements in context as a whole. This means you may not seize on any one word, phrase, or image, or consider only one particular statement, phrase, or passage in isolation. Both parties have the burden of proving actual malice by clear and convincing evidence. To meet this burden, each party must prove by clear and convincing evidence that each statement was made or published, number one, with knowledge that the statement was false, or number two, so recklessly as to amount to a willful disregard for the truth, that is, with a high degree of awareness that the statement was probably false. Actual malice is a subjective analysis that looks to the state of the mind of the person who made the statement. If the person who made the statement is believed it was substantially accurate at the time of its publication, then it does not give rise to liability for defamation. The term actual malice should not be confused with the more common meanings of the word malice, such as ill will or hatred. Actual malice is not established merely because an author was motivated by ill will, prejudice, hostility, hatred, contempt, or even a desire to injure another. In order to find that Ms. Heard republished the original op-ed, including the headline, through a tweet on December 19, 2018, you must find that she retransmitted the defamatory material or redistributed the material with the goal of reaching a new audience. Stated differently, republication occurs when the speaker has affirmatively reiterated the statement. A hyperlink directing readers to a previous article on the same website does not direct the previous article to a new audience. Merely linking to an article does not amount to republication, but adding content to a linked article may constitute republication. You must determine whether any added content was intended to reach a new audience. If you find any content added to the hyperlink was intended to reach a new audience, it constitutes a republication. Further, if you find a republication occurred on December 19, 2018, then in order to find for Mr. Depp against Ms. Heard, you must also find by clear and convincing evidence that Ms. Heard made this republication with actual malice. A principal is a person or legal entity with power or right to control the means and methods of performance by which another person performs the principal's work. An agent is the person who is subject to the power or right of a principal to control the means and methods of performing the work. An attorney has the express authority to do everything which the client expressly authorized him to do, and the implied authority to do everything necessary or incidental to the purpose for which he was retained. Ms. Heard has the burden of proving by the greater weight of the evidence that Mr. Waldman was an agent of Mr. Depp, and that Mr. Waldman was acting within the scope of his agency when he made the statements. You must remember that there is no burden on either party to prove the truth of any of the statements. Both parties were free to offer proof of truth, but by doing so, they do not assume the burden of convincing you of the truth of the statements. The burden remains on each party to prove that the statements he or she complains of are false.
So now that the definitions are made clear, it's time to move on to the evidence, particularly expert witnesses. And you might find yourself a little bit surprised at what the jury can and cannot disregard when considering testimony.
The rules of evidence ordinarily do not permit witnesses to testify as to opinions or conclusions. An exception to this rule exists as to those whom we call expert witnesses. Witnesses who, by education and experience, have become expert in some art, science, profession, or calling may state their opinions as to relevant and material matters in which they profess to be expert, and may also state their reasons for the opinion. You should consider each expert opinion received in evidence in this case and give it such weight as you may think it deserves. If you should decide that the opinions of an expert witness is not based upon sufficient education and experience, or if you should conclude that the reasons given in support of the opinion are not sound, or if you feel that it is outweighed by other evidence, you may disregard the opinion entirely. In considering the weight to be given to the testimony of expert witnesses whose opinions differ, You may consider the ability and character of the witnesses, their actions upon the witness stand, the weight and process of the reasoning by which they support their opinion, their possible bias in favor of the side for which they testify, the relative opportunities for study or observation of the matters about which they testify, and any other matters which serve to illuminate their statements. In considering the weight to be given to the testimony of expert witnesses, you should consider the basis for his or her opinion and the manner by which he or she arrived at it, and the underlying fact and data upon which he or she relied. An expert witness was asked whether statements contained in published treatises, periodicals, or pamphlets are reliable authority of a type normally relied upon by others in his or her field of expertise. This evidence is permitted to test the knowledge, accuracy, and opinions of the expert witness. And if such evidence is established as a reliable authority by expert testimony, it may be considered by you along with the other evidence in the case.
Okay, so in this next part, you're going to hear the judge use the word bald, but it's not what you think. Although the term bald is commonly associated with someone's hair condition, such as myself, it also can be used to describe a way in which someone makes a statement. For example, you could say that's a bald-faced lie, which means that it is shameless, no storytelling, it's direct, to the point, and simply untrue. Now you can also use it to describe the truth as well, but us Texas folk tend to use it for lies. But let's hear what the judge has to say about it.
In considering the evidence, you are not limited to the bald statements of the witnesses. In other words, you are not limited solely to what you see and hear as the witnesses testify. On the contrary, you are permitted to draw from the facts which you find to have been proven such reasonable inferences as may seem justified in the light of your own experience. During the trial of this case, certain testimony has been presented to you by way of video depositions. You should give this testimony the same consideration as to its weight and credibility as you give to the testimony of witnesses who testified here in court. You must not discount any testimony merely because it was shown to you by video recording. When one of the parties testifies unequivocally to the facts within his or her own knowledge, those statements of fact and the necessary inferences from them are binding upon him or her. He or she cannot rely on other evidence in conflict with his or her own testimony to strengthen his or her case. However, you must consider his or her testimony as a whole, and you must consider a statement made in one part of his or her testimony in the light of any explanation or clarification made elsewhere in his or her testimony. Any fact that may be proved by direct evidence may be proved by circumstantial evidence. That is, you may draw all reasonable and legitimate inferences and deductions from the evidence. If you believe from the case that a witness, other than Mr. Depp or Ms. Heard, previously made a statement inconsistent with his or her testimony at this trial, the only purpose for which that statement may be considered by you is its bearing on the witness's credibility. It is not evidence that what the witness previously said was true. If you believe from the evidence that Ms. Heard or Mr. Depp previously made a statement inconsistent with her or his testimony at this trial, that previous statement may be considered by you as evidence that what Ms. Heard or Mr. Depp previously said was true. In reaching your verdict in this case, you are to consider the testimony and evidence. Sometimes attorneys stated objections during the course of this trial and instructed a witness not to answer a question. Objections and instructions to witnesses are not evidence, and you may not consider them in reaching your verdict, nor are you to draw any inference from the fact that an objection was made. You must not consider any matter that was rejected or stricken by the court. It is not evidence and should be discarded. Any amount of damages requested by a party is not evidence in this case. You should not consider it as evidence in arriving at your verdict.
All right, so now for the final part. The judge is going to explain how the jury should decide who should pay damages and how much.
If you find your verdict for Mr. Depp or Ms. Heard, then he or she is entitled to recover compensatory damages without any proof of actual or pecuniary injury. As a result, injury to Mr. Depp or Ms. Heard's personal and business reputation, humiliation, and embarrassment is presumed. If you find either party liable for defamation, then in determining the amount of damages to which the opposing party is entitled, you may take into consideration all the circumstances surrounding the defamatory statements, the occasions on which they were made, and the extent of their publication, the nature and character of the insult, the probable effect on those who heard the statements, and their probable and natural effect upon the defamed party's personal feelings and upon his or her standing in the community and in business. Your verdict should be for the amount that will fully and fairly compensate him or her for, number one, any loss or injury to his or her business; number two, any insult to him or her, including any pain, embarrassment, humiliation, or mental suffering; number three, any injury to his or her reputation; and number four, any actual out-of-pocket losses that were caused by the statements. Mr. Depp cannot recover damages for any harm that occurred after November 2nd, 2020. Ms. Heard can recover damages for any harm that occurred after Mr. Waldman's statements were published. The burden is on the party seeking damages to prove by the greater weight of the evidence each item of damages he or she claims and to prove that each item was caused by the defamatory statements at issue. Neither party is required to prove the exact amount of damages, but the party must show sufficient facts and circumstances to permit you to make a reasonable estimate of each item. If either party fails to do so, then he or she cannot recover for that item. If you have found by clear and convincing evidence that the statements in the op-ed were made with knowledge that they were false or so recklessly as to amount to a willful disregard for the truth, that is, with a high degree of awareness that the statements were probably false, then you may award punitive damages to punish Ms. Heard for such actions and to serve as an example to prevent others from making such statements in the future. You must state separately in your verdict any amount you allow as compensatory damages, if any, and the amount you allow as punitive damages. If you have found by clear and convincing evidence that Mr. Waldman, while acting as an agent for Mr. Depp, made the statements with knowledge that they were false or so recklessly as to amount to a willful disregard for the truth, that is, with a high degree of awareness that the statements were probably false, then you may award punitive damages to punish Mr. Depp for his such actions and to serve as an example to prevent others from making such statements in the future. You must state separately in your verdict any amount you allow as compensatory damages, if any, and the amount you allow as punitive damages. All right.
So now that the rules, the conditions, and the terms are laid out very clearly, it's time for the jury to make their decision. The fate of Johnny Depp is in their hands, but we'll have to wait until Tuesday to find out, or at the latest, maybe even Thursday. And after that, we will give our final conclusion to this entire series. So until then, remember to like, subscribe, and I'll see you on the flip side. Peace!